We're going to be taking a look at a very interesting case that is currently before the courts in Ontario called Restoule versus Canada. This case centers around the 1850 Robinson-Huron treaties with the Crown and annuity rights. So this first slide gives us sort of a general start to finish basic overview of the ruling and the case, which we're going to get into in a few moments. But what's really interesting is this case is really starting to set a different precedent in Canada for how the justice system should be looking at in the interpretation of treaties. So back in 1850, let's take a look at what was going on back then in terms of Indigenous Crown relations. So things were a little bit tense, they were a little bit volatile. We're going to be showing a video shortly which explains a little bit about that. But both sides of the issues were in kind of different positions. So the Crown at the time was going, you know what? We're growing in population. These lands are really amazing. They're full of great natural resources, and we'd really like to take those for ourselves. They were really focused on global expansion. The issue they were facing was resistance from Indigenous people because guess what? They own the land. And so the position of First Nations was, you know what? We acknowledge that these people are here. There's nothing we can do about that. So let's try and find a way to build some relationships so we can move forward together while we protect and preserve our land. Well, that didn't work so well for the Crown because that didn't give them what they wanted, which was surrender of the land, expand their own interests, and completely control all of the natural resources. So the Crown's solution to that was the creation of treaties. So the birth of Indigenous Crown treaties around that time was quite interesting. Both parties came to the negotiation table with various principles that they felt were really important. So the Indigenous principles of negotiation are very similar today as what they were back then. And it was, we're going to negotiate based on respect, renewal, reciprocity, and responsibility towards each other. The Crown came to the table saying, well, we really want to be able to deal liberally and justly with Indigenous nations, but we still want them to give us their land. So obviously two very diametrically opposed methods of negotiation, but they were both willing to come to the table and talk about how to do that. So early treaties were actually quite interesting. They were very, very informed by Indigenous laws, culture, and ceremony. In fact, the Crown often came to the table presenting gifts that were culturally relevant to Indigenous people, like wampum belts, and participated willingly in ceremonies surrounding treaty negotiations. The end result was two very different agreements. One was a written agreement written in English by the Crown, which was problematic, as we're going to see, because most Indigenous people at the time didn't speak or read English. The Indigenous person's way of documenting what transpired in those negotiations was traditional storytelling and among traditional knowledge keepers. And so the knowledge of what was discussed and negotiated during the treaties was passed down generation to generation. So let's take a look at the actual treaties that are part of this legal case right now. And this was the Robinson-Huron and Robinson-Superior treaties. So these were negotiated back in the 1850s by a colonial negotiator named William Robinson. So he was sent in by the Crown. He was a negotiator and a fur trader to try and figure out how they were going to get some land from the people of these nations. And so in 1850, he actually negotiated Treaty 60, which was the Robinson Superior Treaty with Chief Shingwak of the Superior Anishinaabe First Nation. And then in 1852, he negotiated Treaty 61, the Robinson-Huron Treaty, with Chief Negnagoching of the Huron Anishinaabe First Nation. You can see the three of them together in that picture there. Everything looks really hunky-dory. But as we know, things were actually quite tense leading into this treaty, and it was really kind of a rather forced treaty, as we're going to see. There was a lot of tensions going on, and the First Nations people really felt like they didn't have any other choice because they were being steamrolled by the colonizers. Didn't have any choice but to come to the table and try and figure out if they could find an agreeable way to move forward. So these two treaties over time collectively became known as the Robinson-Huron treaties. They include 21 First Nations, and as of today, there are over 30,000 eligible treaty beneficiaries. So let's take an interesting look at the perspective of First Nations people at the time and what was going on, and what really prompted the negotiation of this treaty.
So the Indigenous people fought in the War of 1812 to protect their own autonomy. They weren't fighting to protect the British land. because at that time there simply wasn't any. Those were still Indigenous lands. And it didn't take long before they started to resist and they started to rebel. And of course, again, it was Chief Shingwak and a small band of people that started a rebellion. Chief Shingwak was arrested. He was brought down to Yorktown, what is now Toronto, and he went to court. And he told the judge, "You kick our people like dogs, and these dogs are going to bite back." The Crown at the time said, "We can't charge this man, and we have to let him go because we don't have agreements with them. We don't have treaties with them." They never surrendered their legal autonomy or jurisdiction over how they govern affairs in their lands. But even at that time, when he was arrested, the people were ready to go to war. It was a very volatile time. So of course the British sent Robinson down to make the treaty and negotiated what Canada calls the cede and surrender of our traditional territory, which is false. Which afterwards he actually bragged to the Crown, stating that he was able to get so much land for only $2,500. The British actually offered the Anishinaabe, our tribe, a couple of wampum belts. One of them was a Great Covenant chain wampum belt. And so the idea of that belt was that if one nation was in need, they would roll what was needed down the belt, and it would go to the other person because the two people are carrying the belt. And what happened was the British, they just kept asking for this, asking for that. They kept taking. And nothing was rolling our way. Everything was rolling their way. And because the British kept taking and taking and taking and not giving anything back, it forced a revolt. And it forced what we know now as the Robinson-Huron.
So we can see here a definite disparity in terms of how both sides saw the treaty negotiations. But at the end of the day, they came up with a treaty. And in that treaty was something called annuity rights. And this is very common. It's in most Canadian treaties. And what it says is that the government, the Crown, can use or have access to Indigenous lands. And there could be some basic resource development. We're going to talk about that in a minute. And when they do and they make a profit, that the Indigenous First Nations have a right to annuities obtained through those resources. So the issue with the Robinson-Huron treaties was there was a gross disparity in terms of what the Crown interpreted as their right to develop natural resources. Contrary to what the Indigenous people saw it as, which was basic self-provision, the Crown said we now have a right to mine and do forestry. And so part of the treaty said that there was going to be a growth in these annuity rights. So there's over 600 First Nations in Canada. Nearly 600,000 people have actually been eligible to collect these kinds of annuities stemming from treaties signed between 1850 and 1921. The unique thing about the Robinson-Huron treaties is they're the only treaty that actually has something called an augmentation clause, and that is a prospect of an increase in the resource annuity over time. So as the resource development continues, that amount will actually grow. So the issue is that in the treaty it mentions $4, that they would grow up to $4. This is seen as an annuity cap. Annuity cap, even though the other treaties in Canada don't have augmentation clauses, most have an annuity cap, which is this is the amount that you can make on the development of natural resources. The issue with this is actually that the Crown didn't really see this as something that was going to be going on into perpetuity. They saw this as a really sort of limited time issue because they really believed that Indigenous people were going to either die off or be assimilated. So they did not foresee that 170 years down the road, we're going to be sitting here and talking about, whether or not these caps, the amount that was negotiated 170 years ago is actually fair in terms of current value and all the resource development that's taken place in this almost 200 years. So treaty rights have continued to be challenged after Confederation, which is, as we know, where Indigenous people lost many of their rights. And where it left First Nations people was really in strict poverty. And the sad thing about that is the Crown has actually obtained over $1 trillion in revenue from Indigenous lands since that time. And really, where is Indigenous persons' compensation for that? And the Crown has continued to maintain, well, their compensation is as it was stated initially in the treaties. So in 1890, people of Huron Superior challenged this in court and said, that $4 cap was not to be gone into perpetuity. And the court ruled that, no, it was lawful and final, and there were no rights to appeal at that time. Fast forward to 2015, and there have been many suits sort of in between, and typically speaking, Indigenous rights have not been heard in the courts on this. In 2015, the 11 numbered treaties First Nations actually gathered together and launched a class action lawsuit on the annuity cap amounts of their treaty negotiation agreements, and this was dismissed on a legal technicality. Then we move to 2017, where Restoule versus Canada takes place. So this is quite interesting because for the first time in Canadian history, the judge has ordered a historical recreation of what actually transpired back in 1850 to try and come to an agreement on where we stand now, where things need to go. So all 44 parties to the case were instructed to conduct an investigation into what transpired in 1850, what was the intent, the common intent of the parties in that negotiation, what was the intent of each of the clauses, and present their findings to the court so the judge could rule on this annuity cap and on the augmentation clause. So the 4 parties were the Crown, the Provincial Crown, Huron, and Superior. And they were instructed to use some very unique sources of information compared to what we typically see in courts. We're used to seeing written treaty documents being considered colonial records and historical texts, but the judge also wanted to include Indigenous ways of history keeping, which was Indigenous knowledge keepers, elders, and Indigenous oral tradition. This was very unique and very precedent setting. So what the judge wanted to look at was common intention. And why that was important is, Justice Hennessy said, finding the common intention starts with the premise that treaty making was seen both by Indigenous peoples and the Crown as a worthwhile enterprise aimed at advancing both peoples' interests through agreement. So you can see the many different things that were looked at in this historical investigation to try and find what that common intention was back in 1850 so we could find a way to move forward in the interests of both parties today. So what was the position on the parties? So Canada and Ontario, I think, as can be expected, said, yes, we acknowledge we were supposed to pay up to $4 a person. That's really the maximum liability that we have here. Any increase beyond that, sure, we could consider it. We'll consider requests, but we have to use our discretion, and really there's no requirement to do this. So we could increase beyond 4. We might consider ex gratia payments, but it's really our unfettered discretion. What was the position on review of the Huron Superior First Nations? Well, let's take a look at that.
There were 20 chiefs that signed, and there was some British officials. But what's funny is that years later we found out that the British that actually signed the treaty, that negotiated the treaty, were actually bragging to the Crown after about how much they got for so little. And so the written document that states a land surrender to the Crown and her heirs forever, and it gives mining special privileges. And so the written document is an absolute lie. Our oral history and our songs state that the treaty was something different. And so I have to question the very foundation of treaty right now as we know it. What they agreed to was that the British were allowed to live in Indigenous territories for a little bit, and were allowed to dig the depth of a plow to feed themselves for gardens, and that it wasn't a permanent agreement, that it was a conditional agreement, and that the waters were never to be surrendered, or the land, and that the British were to be given free passage on that land. That's what I was.
So where did this land? Obviously there's a huge disparity in what both parties believe was initially agreed upon. And so what did the judge decide in consideration of this? So the judge, stated that as the historical and cultural context demonstrates, the parties were and continue to be in an ongoing relationship. And so let's look at how we can best reconcile both parties' interests. The judge found that William Robinson, the colonial negotiator, did not intend the $4 cap to be fixed. In fact, the Crown at the time promised to increase the collective annuities without limit, regardless of the fact that they didn't think it was going to continue on forever. That was in fact what was promised. The Crown also, interestingly enough, the judge said the Crown's interpretation is not unfettered and their discretion on application could not be trusted. And so, this was really where the Crown came and said, okay, well, fine, then we should be allowed to interpret how we're going to apply this. And the judge said, no, I don't think that can be trusted in view of how this has been handled up till now. So the interesting thing is that only the provincial Crown has actually appealed this decision. So not that the federal Crown is happy with it, but they sort of took to heart, the judge's comments about how historical relationships should have been. And the Crown Indigenous Relations Minister, Carolyn Bennett, said in a short statement that the federal government now preferred moving forward in this area with negotiation as opposed to litigation. The Ontario Crown has appealed, and in their court documents state the grounds for their appeal is that the trial judge erred in her interpretation on the annuities provision of the Robinson treaties. And while they said they would be happy to go into negotiations, they're still going to litigate. So they're hedging their bets through the court system, which has really left a sour taste in the mouth of the Indigenous people that they're negotiating with, because it shows sort of a bad faith moving forward into negotiations. So the legal implications are quite interesting. The case is being closely watched by First Nations the country over. As we noted, most treaties actually include annuity rights. And so this case has reaffirmed the constitutional rights under Section 35 to treaty rights. It has also set a legal precedent that we must consider the common intention in determining treaty promises. And that is going to require looking back at what took place at the time of negotiations. In terms of the law, it established that Indigenous laws and governments must inform the courts on the decisions of the courts in interpreting those treaty rights, and that expert testimony can't just include Crown ways of documentation anymore. It must include Indigenous ways of knowledge keeping. So certainly an interesting case to keep our eye on. I'm very interested in seeing how this moves forward into phase 2 of this trial, and I hope that you enjoyed hearing about it today.